Thank you for having me here to discuss what is usually a controversial topic, at least in my academic circles: birthright citizenship, and in particular, its applicability or non-applicability to illegal or unlawfully present aliens and temporary sojourners, or temporary visitors, as we might say today. Let me start with the title that the organizers gave this talk. They entitled it, "The Case Against Birthright Citizenship." That title, however, is quite inapplicable to my talk. I do not intend to argue against birthright citizenship at all, but rather to argue that the question is, what is the rule of birthright citizenship to begin with? What is its scope? You see, the conventional wisdom or assumption is that birthright citizenship means one is a citizen by mere birth on the sovereign's soil. But this raises some puzzles. Namely, what do you do with the children born of foreign ambassadors? Or to the soldiers of foreign armies? The common law did not recognize birthright subjectship or citizenship to those children. Why not? Well, the conventional wisdom says they're just exceptions to the rule. But what if I told you that foreign ambassadors and foreign armies are not an exception to the rule at all? That rather the rule has never been mere birth on soil. The rule instead at common law was that a child born on the king's soil and under the king's protection was a birthright subject. The children of ambassadors were not born under the king's protection, but rather under the protection of the foreign sovereign represented by the father, the ambassador. That is precisely how William Blackstone explained the rule in his influential commentaries on the laws of England. The children of invaders similarly were not born under the protection of the king. So said Sir Edward Coke in Calvin's case, the leading and influential common law case on birthright subjectship from 1608. Thus, ambassadors and armies are not an exception at all, but rather clarify the very rule in question. One must be born not only on the soil of the king, but also under his protection. So how did this common law rule apply to unlawfully present aliens? Really, the question is, how would this common law rule have applied to unlawfully present aliens, given that there were generally few immigration restrictions in England at the time, and there was never a test case? Well, it turns out that from the Middle Ages through the 11th, 12th, and 13th centuries, to come into the realm of England required the king's permission. This permission was granted in what was called a safe conduct. It was a document issued by the king that authorized some foreign individual to come into the realm and that extended the king's protection to that individual. Thus, the safe conduct issued to merchants from Cologne in 1157 guaranteed that they would be under the king's, quote, custody and protection. In 1316, the king issued letters of safe conduct to 2 French knights. The letters stated that they were taken under our, being the royal possessive, under our protection. The patent rolls of the 14th year of the reign of Henry III includes, to take one of many examples, a letter of safe conduct to one William of Wynham. The safe conduct stated that William, quote, has letters of protection for himself and his men when they come into the land in power of the king with their goods and merchandise. Now, eventually, trade was opened up to foreigners, and general statutes and charters were enacted granting a more general permission to foreigners to enter the realm and granting them protection. Magna Carta guaranteed to friendly aliens, quote, safe and secure conduct to engage in trade unless they have been previously and publicly forbidden. The Carta Mercatoria of 1303 was a general grant of safe conduct to merchants from various European states. It specifically guaranteed them our protection. A 1353 statute in the reign of Edward III similarly provided that, quote, merchant strangers may safely and surely under our protection and safe conduct come and dwell in our said realm. So it is true that aliens with permission to be in the realm were understood to be under the protection of the king. That is why Cook and Blackstone and others explained that their children born in the realm were indeed natural-born subjects. That is because with the king's permission came the king's protection. Even enemy aliens aliens from nations at war with England, or later the United States, could have the sovereign's protection if they had the sovereign's permission to stay. Here is how Chancellor James Kent explained it in a case stemming from the War of 1812. Quote, "A lawful residence implies protection." So at common law, it seems to me anyway, that birthright subjectship would not have applied to unlawfully present aliens because they were not under the protection of the sovereign, because present without the sovereign's permission. Now, what about temporary visitors? Here there is more evidence that the common law rule would have applied. Such visitors with permission to be in the United States were under the protection of the United States, hence a judge in 1844 in New York applied birthright citizenship to a child born in the United States to a temporary sojourner. But the application of the rule to the situation was by no means obvious, and it remained contested. After all, when the common law rule developed in feudal Europe, international travel was not common. Should the rule therefore be adapted to modern times? Many seemed to think so. Here are two judges on a New York appellate court in 1860. Quote, "By the common law, when a subject is traveling or sojourning abroad, either on the public business or on a lawful occasion of his own, and with the intention of returning, that subject continues under the protection of his sovereign power, such that his children, though born in a foreign country, are not born under foreign allegiance and are an exception to the rule which makes the place of birth the test of citizenship." Justice Joseph Story, in his commentaries on the conflict of laws, wrote that a reasonable qualification to the rule of birth by soil, quote, "is that it should not apply to children of parents who were itinerantly in the country or abiding there for temporary purposes." In another antebellum treatise, Henry St. George Tucker, the son of the more famous, admittedly, constitutional commentator St. George Tucker, stated as follows: "Though a child be born in the country, yet if both his parents were strangers not designing a permanent change of country, it would be sufficiently obvious, that as he must follow the condition and succeed to the rights of his parents, he would, on the principles of natural reason, be considered as much a stranger to the country as his father." In the Civil War, the military authorities in Louisiana had to determine whether children born there to French subjects were liable to be conscripted. They concluded yes, if the French parents were permanently domiciled residents. Okay, now, one might say, what does any of this common law history have to do with the language of the 14th Amendment, which says anyone born in the United States, subject to the jurisdiction thereof, is a citizen by birth? First, the drafters at the time stated that the language was intended to have identical effect to the citizenship provision of the Civil Rights Act of 1866, but to clarify that Indians who had not assimilated into the United States society were excluded. So what did they say about the Civil Rights Act, which provided birthright citizenship to anybody, quote, "not subject to any foreign power"? Senator Lyman Trumbull, the leading drafter in the Senate, explained the bill in a letter to President Andrew Johnson. He stated that the bill made citizens of children born to domiciled parents. James Wilson, the chair of the House Judiciary Committee, when introducing the legislation in the House, stated that children of ambassadors and of temporary sojourners would be excluded. John Bingham, the principal author of the 14th Amendment, and William Fessenden, the chair of the Joint Committee on Reconstruction, also suggested their understanding, it's more tentative on both counts, that children born of temporary sojourners were not citizens. Many writers after the adoption of the 14th Amendment similarly suggested that it applied only to permanent domiciled residents, and lawful ones at that. People today like to point to the Wong-Kim-Ark case, but in that case, the Supreme Court explained that every citizen or subject of another country, while domiciled here, is within the allegiance and the protection, and consequently subject to the jurisdiction of the United States. The court then repeats, Wong-Kim-Ark's parents, quote, "are entitled to the protection of and no allegiance to the United States so long as they are permitted by the United States to reside here, and are subject to the jurisdiction thereof in the same sense as all other aliens residing in the United States." Now, I will have to stop here for my initial remarks because of time constraints, but suffice it to say, it really would be quite astonishing if the language of the 14th Amendment extended to the children of illegal aliens or temporary visitors. It would be quite astounding if the language the drafters used to clarify a point about Native Americans inadvertently expanded the birthright rule from what likely would have been the rule at common law. They would have inadvertently expanded the rule beyond that of the Civil Rights Act. They would have inadvertently done much more than was necessary to accomplish their central objective of giving citizenship to the freed people. And they would have inadvertently constitutionalized a rule over which, at a minimum, reasonable people can disagree, and which, quite frankly, behind a veil of ignorance, most nations would probably not choose, originating as it did in medieval times and for feudal purposes. It would be astonishing if they did all of that inadvertently by the phrase subject to the jurisdiction thereof. So let me really conclude the opening by saying that there's far more support for President Trump's executive order on birthright citizenship than you would know if you merely walked in the halls of academia, as I do, or listened to the mainstream media, as I don't. So I urge especially the judges who are to hear the merits of these cases to reserve their judgment and really dig into the history, because what they find might surprise them. Thank you.